On behalf of the Simpson Center, the Graduate School, the University of Washington Alumni Association, the Tech Policy Lab, DX Arts, and the Henry Art Gallery, it is my pleasure to welcome you to the first of this year's Walker Ames Public Lectures. My name is Ed Shankin, and I'm a professor in the DX Arts program, that's Digital Arts and Experimental Media. Before I introduce tonight's speaker, I would like to share a little bit of history about the Walker Ames Lecture Series. Edward Ames and Maud Walker were natives of Maine who met one another in the state of Washington. They were married in 1888. In his professional life, Mr. Ames was a leader in the timber industry who promoted sound business practices and conservation. Privately, he and his wife devoted themselves to cultural pursuits. Together, they amassed a discriminating collection of rare books and first editions, and that collection, along with their home, was generously donated to the university. In 1932, they also established a bequest, the proceeds of which support this professorship program. Their gift has provided our community with access to a rich array of scholars. To date, over 450 scholars have visited the University of Washington campus with the sponsorship of this endowment. Tonight's speaker, Marc Rotenberg, is the founder and president of the Electronic Privacy Information Center, known as EPIC, in Washington, D.C. He teaches information privacy and open government at the Georgetown University Law Center. Since its founding in 1994, EPIC has been on the front lines of many of the leading privacy battles in the United States. And Marc tells me he's also very actively involved in the EU. Marc has won professional awards, including the World Technology Award in Law and the Norbert Wiener Award for Social and Professional Responsibility. Marc is also a tournament chess player, and we can all sleep more soundly knowing that our privacy is being safeguarded by a 3-time Washington, D.C. chess champion. On a more personal note, I have known Marc since the 1970s, when he was my camp counselor. So it is really a very special honor for me to introduce him here to the University of Washington community tonight. Marc not only taught me the finer points of goalkeeping, as a soccer goalie, but got me involved in writing letters for Amnesty International. This kindled my political awareness and concern with social justice at an early age, and remains an ongoing inspiration in my life as a scholar and as a citizen. In my mind, Marc is the ideal embodiment of the public intellectual, whose scholarship and activism have had an immediate, significant, and lasting impact on preserving civil liberties. Please join me in welcoming Marc Rotenberg. So happy to have you here.
That was very kind. I'm glad there wasn't too much detail about our summers at camp. It would not work for a talk on privacy. So,
you taught me well.
Yeah. And that chess thing, by the way, is in case privacy doesn't work out. I'm going to play the tourists in the park in Washington and make a little money on the side. So I wanted to thank you all so much for being here this evening and coming for this talk. I travel a lot around the country and actually around the world talking about privacy issues. And one of the things I can never get over is how constant our awareness of privacy is. I can begin a talk with some boilerplate facts. I can tell you, for example, that over the last 10 years, according to the Federal Trade Commission, the number one concern of American consumers is identity theft. I can tell you about a recent survey from Pew Internet, which finds that more than 90% of Americans feel that they've lost control over all personal information. or give you some statistics about data breaches in the United States, a number that goes up each year. But I suspect you're all this week kind of thinking about Uber, the ride-sharing service, right? How many people have been following the news on that? I found this just extraordinary. And I didn't know very much about Uber at the beginning of the week. I did find this out, though. I learned that when someone at Uber got very upset about critical reporting on the company, he thought it was appropriate to say to someone else that he was going to dig into the private life of a journalist who was reporting adversely. And then I learned that Uber has something called a God View tool, which allows them in real time to know exactly where every driver and every customer is. And this tool was deployed against a reporter who showed up at the Uber headquarters in New York and was a little bit surprised to be greeted by the manager there, who said that he had been tracking her movements as she traveled across the city. Politico asked me, well, what do you think about all that? And I said, well, I think that's incredibly creepy. And it made me start to think about the kinds of data that's being gathered about so much of what we do in so many ways that even when you think you're on top of the practices of large internet firms and following closely the activities of federal agencies, something new comes along. And I guess this raises the perennial question for us in the privacy world: is this just something we need to get used to? Is this part of the cost of the benefits and convenience of modern life, of modern technology, of being able to get a car when maybe the local taxi service doesn't work so well? And that's really the starting point for my talk this evening, because I'm going to tell you about how we started EPIC, what we are trying to accomplish, and what I hope we will still be able to do. My story actually begins a little more than 20 years ago. I was working for a group at the time, and I'm happy to see one of the people who I was working with back then here tonight, John Jackie, with the Computer Professionals for Social Responsibility. And we were a group of technical experts. I was focused on civil liberties issues. And around that time, there was a proposal from the National Security Agency called the Clipper chip. And the theory of the Clipper chip was that people using public key cryptography in the United States, which the internet was now making possible on a widespread basis, would end up with too much privacy. And the government needed to do something about that. You don't want people to have secure communications, private communications, confidential communications, because they might end up doing something bad. And so the National Security Agency proposed a technical standard which required that any service provider that enabled encryption also keep a private copy of the private key and store it with a government escrow agent so that any message could be decrypted at any point in time. And I was working with technical experts, computer scientists, some pretty heavy names in the crypto field, Ron Rivest and Whitfield Diffie and David Schaum and others, and I said to them, what do you think? I mean, I don't have the background you do. The government has made an argument for why it needs access to our private messages. Is this something now that should become a national standard? And there was a very interesting discussion. It was partly about civil liberties, it was partly about security, it was partly about the nature of standard setting. It was very much about the kind of society that we would be living in as the internet evolved, as we became more dependent on the internet. 1994 was also a very interesting year in internet history. It was kind of the turning point. It was when the first commercial services became available. It was when people started thinking about exchanging credit card information online and buying stuff. And so we wrote a letter to President Clinton very respectful letter signed by 42 computer scientists and legal scholars, and we said, you know, we've thought about this and we understand the concerns that law enforcement and NSA and others have about circumstances where this kind of technology might be misused, but we think it's a mistake. We think it's a serious mistake for the government to mandate this type of ongoing surveillance capability. And then something kind of remarkable happened. We had just, at that time, created a web presence, and I posted the letter online. And it was kind of a simple, you know, experts write to the president, ask him to rethink the Clipper chip proposal. And then I started getting emails. People wrote to me and they said, well, Mark, I don't entirely understand cryptography or the Clipper chip, but I have many of the same concerns. I'm concerned about privacy, I'm concerned about security, I'm concerned about structure of government. And they said, would you please add my name to that letter you wrote to the president? And over the course of about 6 weeks, I got about 50,000 emails from people asking that their name be added to the letter to the president. We actually had the first real internet-based petition. Now, I gotta say, for some of the younger folks here, 50,000 names probably doesn't seem like a lot to you, but for the older folks, you have to know that was about half the internet 20 years ago, right? I mean, there weren't a whole lot of people, you know, online with email accounts. So we felt we had accomplished something pretty important. And when that petition was delivered to the White House, and by the way, we printed it out in large print, just a little bit of advocacy advice. You always want to look a little bit bigger than you are. So we had a nice thick stack of paper that went to the White House. And the Clipper chip was withdrawn. The mandatory key escrow proposal that the NSA had pursued 20 years ago through our efforts and the efforts of many others was eventually pulled back. Now, as I'm sure you all know, that was not the end of the story when it came to NSA communications surveillance. So I'm going to hit the fast forward button and take you to last summer, June 2013. We were all gathered in Washington to celebrate our 20th anniversary. We gave out awards that evening, first week of June, to Senator Ron Wyden and Senator Rand Paul, proving that privacy truly is a bipartisan issue. And then later that week, a story broke in The Guardian. The same week, we had just celebrated 20 years of EPIC and our Clipper chip work and everything else. And the story in The Guardian, the first story in The Guardian, provided a document from a former NSA contractor, which appeared to be an order from the Foreign Intelligence Surveillance Court authorizing the routine collection of all telephone records for all domestic telephone calls within the United States. Now, I've been teaching privacy law for almost 25 years. And I looked at that court order, and my thought was, A, this is something off the onion. B, this is the attachment to a privacy law exam, draft an unlawful court order. Or C, you know, someone was just messing around. Now let me tell you on number B, which is letter B, what I actually went for. I took out my pen and I'm looking at this court order and I'm thinking, relevant to an ongoing investigation, all telephone customers in the United States. Well, that's obviously wrong. So I'm circling that and thinking to myself, I'm going to do pretty well on this test. And then I realized it was the actual order. And that, you know, whatever you may say about Edward Snowden, who this past year we ended up giving the same award to that we had given to Rand Paul and Ron Wyden the year before, I could not get away from the fact that he had revealed the most extensive form of government surveillance in US history, that the capabilities of the NSA had been deployed to collect your telephone records. You can sit in the back, it doesn't mean your telephone records aren't going to be collected, right? Now, I don't know how many people in this room feel that they are the proper subjects of a criminal investigation. I have to say, I recently went through a background check. It was the first time in my life I did that. I passed. I was even a little disappointed that I passed. I thought maybe I hadn't been living the life I thought I was living. But nonetheless, I don't think that I should be subject to that kind of surveillance, and I don't think you should be subject to that kind of surveillance either. And so a remarkable thing happened. My little organization, EPIC, which is, just a dozen hardworking people, a bit of legal background, and a pretty good attitude about the great American tradition of filing lawsuits, we all sat down and said, this just can't be right. And we had to figure out how exactly are we going to challenge this. This is the Foreign Intelligence Surveillance Court, a secretive court that reviews secretive activities, that issues secretive opinions, that meets in secret. I actually stood in front of the door once. There was a little sign and a lock on it. I got a selfie there. I'll maybe put it up at some point. But I've never seen the courtroom. So we drafted a petition to the US Supreme Court. It was a pretty good argument, actually. We explained that the Foreign Intelligence Surveillance Court had exceeded its authority when it told the telephone company Verizon, you have a legal obligation to provide all of these records on all of your customers on an ongoing basis. That's what the order said, by the way, and similar orders exist for all the other telephone companies in the US. And it was a good argument. It was well written. Most people said to me, well, this is kind of crazy what you're doing. No one's ever challenged an order of the Foreign Intelligence Surveillance Court. And by the way, if you are going to challenge an order of the Foreign Intelligence Surveillance Court, you don't go to the Supreme Court first. You go to, another federal district court, make your argument there, and then they sort it out. Maybe eventually you get to the Supreme Court. Well, we spent a lot of time looking at that issue, and I actually concluded that the only way we could challenge the Foreign Intelligence Surveillance Court was with a petition to the Supreme Court, because I suspected that if we went to another court, the government would likely argue that court doesn't have authority to review what the Foreign Intelligence Surveillance Court does. And guess what? When the ACLU went to another court, federal district court, and said you have to review this order, that's exactly what the government said. They said go to the Supreme Court. To us, they said go to the district court. I'm thinking that's a pretty good game they've got going. But the other thing that happened when we put together our petition, much like the Clipper petition we had done 20 years earlier, is that all sorts of people started to come forward and say, we want to support what you're doing. We had law professors, experts in national security law and privacy law and Supreme Court jurisdiction writing amicus briefs on our behalf, people whose political views are over here and over here, writing briefs on our behalf. And then I got a call from someone who said that she was organizing an academic conference and that she had been in touch with former members of the church committee, including Vice President Walter Mondale, and he would like to sign on to the EPIC petition to the Supreme Court along with Senator Gary Hart and other members of the church committee, and they did, by the way. We had 4 amicus briefs filed in support of our petition. Well, ultimately, the Supreme Court chose not to take our case. It was a very unusual procedure that we were following. But I guess we got a little bit of satisfaction at the end of this term. As you may be aware, in another somewhat related case concerning the privacy of cell phones, the Supreme Court ruled unanimously, remarkably, and entirely surprisingly to me, that the search of a cell phone must be subject to a warrant. And as a consequence, even in a circumstance when a person might be arrested, the police must still obtain a warrant before they inspect that person's phone. So you never really know, I would say, when you undertake a campaign, when you begin a petition, even when you put together a lawsuit to the Supreme Court, what the outcome is going to be. You give it your best shot, you stay focused on your goal, and you hope that others will join in support. I'll tell you one other story about our experience over the years, and then talk a little bit about some of the challenges ahead and what I think we might do. But I think this other story will also be familiar to you. It concerns the body scanners in the airports, right? So we started looking at those scanners about 10 years ago, because after 9/11, there were all of these new surveillance technologies deployed in the United States. There were also some that were proposed and beaten back. One of my favorite battles concerned the efforts of John Poindexter to put in place something called total information awareness. And the goal of total information awareness was not only to gather up and link together databases, but also to create new types of tracking techniques that didn't previously exist, like facial recognition, for example, or trying to determine a person's identity by the way he or she walks. It was the most ambitious surveillance program one could imagine. It was the subject of lots and lots of criticism, and then Poindexter came up with a brilliant solution. Rather than to scale back the program, put in place privacy safeguards, or maybe some means of independent oversight, he decided to rename the program, called it Terrorist Information Awareness. We acknowledged that on our website. We said, name change, problem solved. Of course it wasn't. The big one for us after 9/11 were the airport body scanners, and that project came about because we had filed a Freedom of Information Act request where the Transportation Security Administration to obtain the technical specifications and contracts for the devices that were to be deployed in U.S. airports. And we were asking a fairly simple question. What does this technology actually do? How detailed an image of the human body will the operators see? What type of privacy safeguards and filters are in place? Will it actually detect explosives? That seemed to us an appropriate question to ask, since that was the reason these devices were being deployed across the country. And when we got back the documents, we saw something remarkable. The machines had, you could say, using the Uber terminology, a God view setting, which essentially allowed the operators to turn off the privacy filters if they wanted. The devices were also designed to store, record, and transmit images. One reporter said, "How did I know that?" And I said, well, I'm just looking at the hard disk drive, the USB port, and the Ethernet connection and thinking that's not all for decoration, right? And on the critical question, could the devices actually detect explosives? The answer was sometimes. The devices could detect ceramic knives and plastic guns and C4 if it was in a hard brick format. Because what the devices were intended to do was find dense objects that were non-metallic. That was viewed as the primary threat after 9/11 and one of the vulnerabilities in the U.S. air safety system. Well, we looked at all this and we said, this doesn't look right. It's not doing what it's supposed to do. It's more intrusive than they've told us. And as a matter of law, by the way, it might actually be unconstitutional because people shouldn't have to strip naked before they get on an airplane. Seems reasonable. We petitioned then Secretary Napolitano to suspend the program and to conduct public hearings. And we said at the very least, let's give the public some opportunity to comment as to whether they believe this is an appropriate way to do airline safety. She eventually responded saying, in effect, we've considered your concerns, we think we've addressed them, now go away. That happens a lot in Washington, by the way, but we're not the right group to do that with, because we later sued her. I mean, we sued the agency, and then we sued her 3 times, but I'm going to come to that in just a moment. The other thing that was happening as we were going after the airport body scanners is that medical experts were beginning to weigh in. Now you need to know there are 2 categories of devices. There are the millimeter wave devices, which are presently in the airports, and there are the backscatter X-ray devices, which have been removed from U.S. airports in large part because of the lawsuit we eventually brought against the Department of Homeland Security. The medical experts were saying there may be some risk here to the additional radiation exposure if air travelers routinely go through these devices. It's hard for us to assess that risk, but there should be some independent evaluation, which struck me as one more reason that there had to be a public opportunity, including the participation of experts, to evaluate what the risks to the American public might actually be if these devices were deployed across the country. And that was essentially the lawsuit that we brought against the Department of Homeland Security in 2010, saying that there had been no opportunity for public comment and that there was, as a matter of law, a right before the agency uses these devices as it proposed to do for the public to express its views. Well, somewhat remarkably, we actually won that case. The D.C. Circuit Court of Appeals ruled that the agency had violated the law by not giving the public the opportunity to comment. It said that it could leave the devices in place, but the public must still be given its day to express its views, and in a wonderful world said that the agency must act promptly to take public comment. That was in July of 2011. I asked people, what do you think promptly means? And I said, well, are you like trying to get your kids to bed at night, or are you a federal agency about to issue a rule? You know, lot of space in between, yes? So we waited 6 months. We thought that should pretty much cover anyone's definition of promptly. The agency still had not issued its rule. So I sued Secretary Napolitano, and we got into that bit of litigation. They said they're going to do this promptly. And I waited another 6 months, and I sued her again. And I think the third suit happened toward the end of 2012, but here's the remarkable ending to the story. The TSA had concluded during the period of the litigation and ongoing investigation by Congress that maybe it wasn't worth the battle to keep the backscatter X-ray devices in U.S. airports. And they quietly unplugged them, boxed them up, and sent them back. We were pretty happy about that, actually. So, good reason to go to law school. Anyone here is thinking about it. Who knows what you might do. I'll tell you a couple more of our recent cases and then talk a bit about some of the challenges I think we're facing. I mean, we've been involved in a whole range of activities in Washington on the consumer privacy front. We went to the Federal Trade Commission when Google was battling with Facebook over a social network service, and you may recall that Google originally wanted to introduce Buzz, but instead of saying to its Gmail users, would you like to sign up for Buzz, Google decided to sign up Gmail users for Buzz. Now that doesn't work out so well if you think about an email address book, which is generally kind of private. versus a social network friends listing, which tends to be kind of public. And Google took the email address book and made it public in Buzz, upsetting lots and lots of people. We went to the Federal Trade Commission, objected to that, and the FTC eventually agreed with us, basically subjected Google to privacy obligations, which they're now expected to follow. We had a similar battle with Facebook when they changed users' privacy settings. I find this personally very frustrating, right? I mean, when you actually take the time to go through a service's privacy settings and you say, okay, I'll do this, but not that, and I'll do this, and then the company subsequently decides, maybe it's a change in business model or some other reason, to change your privacy settings, invariably leading to a greater disclosure of your personal information than you had intended, but saying to you, well, if you wanted your original settings, you can always change them back, right? I've seen a lot of that, and I find it enormously frustrating and incredibly unfair. But again, being a good old Washington lawyer, I just go to the Federal Trade Commission with a complaint, and we get into the midst of a big battle. Oftentimes, those have worked out. On the open government front, we recently obtained from the National Security Agency the formally classified cybersecurity directive that was signed by President Bush in 2008, gave the NSA the authority to conduct surveillance on domestic communications. I didn't think they were supposed to do that. We got details of the FBI's Next Generation Identification Program. It's the largest biometric database in the world, and if you think about how law enforcement criminal record systems might operate, you would think maybe there should be a distinction between the people who are the criminals and the people who are not, right? But that's not really the plan for next generation identification. It is capturing everybody's information. Finally, I happen to like this particular photo. We decided to give this FOIA lawsuit a name, Eyes Over Washington. It's about the Army blimps now up at the Aberdeen Proving Ground, which are there partly as a defensive measure. Two blimps, one of them has radar to detect possible attacks on the nation's capital. The second blimp has the armaments, including Hellfire missiles, right? So this is pretty serious, scary stuff. But an interesting question about the surveillance capabilities of the blimps is, in addition to radar, do they also do visual surveillance? Could you, for example, identify and locate people from above using this new J-lens technology? And the Army said, no, of course that would never happen. We would never do that. And then we found this video on the Raytheon site, one of the contractors for the project, saying, hey, people with those J-lens blimps, guess that would be the Army up at Aberdeen, you can now upgrade. And the upgrade includes surveillance cameras, giving you the ability to actually see and identify people on the ground. And I'm thinking, blimps, video surveillance, Hellfire missiles, I'm going to be really careful speeding in DC. This is not going to turn out well. So something to keep in mind. All right. Look, it's kind of fun. It's been fun over the years doing what we do at Epic. I mean, we've had some successes, we've had some setbacks. But I will say, over this period of time, I have developed a fairly strong philosophy about how we should think about emerging challenges to privacy. And I'm just going to share these thoughts with you tonight, and I appreciate your responses, your criticisms, your insights. But I'll tell you, one of the first things I came to believe about privacy is that this is a right, this is an interest, this is a value that we need to assert not only as individuals, but as members of a community, of a political system, people connected by family and by friendship. There's a tendency, I'm afraid, sometimes in the privacy world to see this as all very much about one person's preference versus another. I remember during the airport body scanner debate I'd oftentimes hear from, some very decent person who said he couldn't quite understand what my concern was. He said, if this makes the nation safer for me to go through one of these devices so that they can be assured that I'm not a threat to another passenger, I'm willing to do that. People said that to me a lot in the debate, and I kind of respected it. I think people are, in that respect, kind of, wanting to do the right thing. But then I would say, well, okay, that's a decision you've made. How do you feel about your spouse going through the scanner? How do you feel about your child going through the scanner? How do you feel about your mother or your father? Do you feel that they too should make that sacrifice that you seem willing to make? Is that really fair to them? And then, people start to rethink. It's not just about their own trade-offs or judgments or evaluations. It's about something bigger, and I think that's important. I think it's also important that we have to reject a lot of the myths that hang over the privacy debate. There's a lot of fatalism out there, a lot of people saying, privacy is gone, get used to it, it's one of the things we give up in our modern society. I can't imagine anyone saying that about clean water, clean air, auto safety. I mean, that's one of the things we just have to give up, get used to. It's part of the benefits of industrial society. It's actually one of the things we need, right? Because without it, the other stuff no longer looks quite so good. And I think that's absolutely true about privacy in our information society. Without privacy, a lot of these benefits no longer look so good. I've also rejected the idea, the so-called balancing, right? I've been in a lot of debates over the years where people say, well, where is the balance? How do we strike the balance, between security and freedom? Endlessly, I've been in those debates. And then I remember after 9/11, I was invited to a debate in Toronto, and the conference organizers had picked this wonderful theme for the conference, and it entirely changed my view of America post 9/11. Conference was titled, "The Security of Freedom." Wow. No balance, no trade-offs, simply the proposition, the security of freedom. Think about that. Something else I'd like you to think about is that the information that's being collected about you, it is your information. It describes you, who you are, what you believe, what your interests are, who you know, how you spend your time, what's of value to you. This is your personality. And maybe you choose in some circumstances to reveal certain parts to certain people or to certain businesses or to certain government agencies because you understand that it's necessary, right? But you don't have to feel that you've lost control, because one of the things that modern privacy law does is it says that when people give information to others, they still retain some control, some say over how that information is used. Privacy law exists precisely because when you retain the information physically within your space, you don't need any claims against anyone else. These issues only arise at the time that you've turned over data to others, and that's when you should assert control. I've become increasingly concerned about the amount of personal information that's being collected by large companies. They really don't know what to do with it. They don't protect it. They don't encrypt it. And then you get these notices, right, about data breaches. And then you get like 90 days of free identity theft monitoring service, which you can then subscribe to for $29.95 a month afterward, right? That's quite a business there. Lose your data and then charge you to know how bad the problem is. I think companies that, simple terms, can't protect information just shouldn't collect it. And the risks of the loss of personal data are actually going to accelerate, because we're about to enter an era where we will become increasingly dependent on biometric identifiers. Your iPhone 6, right? Really cool. great authenticator, very happy that Apple said, we don't have any backup, it's all with you. But when that authenticator is compromised, there are going to be problems, and the risks of security breaches will remain. I think finally we need to think about privacy creatively. And I think we need to understand that in privacy there are many, many paradoxes. One of the most important paradoxes to understand is that one of the best ways to safeguard privacy, I think, is through increased transparency. I think we need to know a lot more about the practices of organizations, businesses, and agencies that collect and use personal data. And I think particularly in our era of big data, we need to push for algorithmic transparency. We need to know the basis of the decisions that impact individuals. We need to know what factors an agency uses in border control, for example. Does it take nationality into account? Does it take race or gender into account? We don't know right now. We don't know why people are pulled aside for secondary screening, because that technology, that process is entirely opaque. We also need to think about the paradox of privacy and the free flow of information. You know, it's an odd thing. I go back and forth between the US and Europe, and in the US people say, well, of course, there's a big conflict between privacy and the free flow of information. Europeans don't say it this way at all. They say, well, if you're going to exchange information, you need to have some confidence that the information will be properly protected. That's the nature of a communications network. Privacy enables the free flow of information. And increasingly, I also believe that privacy is a spur to innovation. People say sometimes, well, you know, we want to do this, but of course we really can't because there are those privacy rules that prevent us from doing it. It would seem to me that one of the remarkable ways to think about innovation today in America, when so many people are concerned about identity theft, so many people are concerned about data breaches and financial fraud, is how do we do online commerce? How do we do online payment? How do we do transportation? How do we do all of these incredible things that the digital environment enables in a way that's secure and private? How do we use a ride-sharing service without having to worry that somebody with a God view feature knows where we are at any moment in time? Well, I'm just going to wrap up with this thought and open it up for questions. You know, people in the privacy field oftentimes come back to George Orwell's 1984. And I guess like most people, 1984 had a big impact on me, but I took a lesson away from Orwell's 1984. You know, there are a lot of people who read it and say, well, that's eventually our future. That's kind of a prediction. Maybe not today, maybe not 5 years. I mean, get out to the singularity or something around there. You know, we're going to be in a complete Orwellian surveillance state. But I didn't read Orwell's 1984 as a prediction. I read it as a warning and as a challenge and as a reminder of what might happen tomorrow if people fail to act today. So EPIC is very much about acting today, and I guess if I've given you all a few thoughts about what you might also do, I hope you will act as well. This is how we protect our freedoms tomorrow. Thank you very much. So I know we're set up for questions, so if you'd like to come down, we have mics here. I'd be happy to take your questions. You don't have to identify yourself, by the way. I completely respect that. You can be anonymous till I figure out your IP address. Sir.
Do you have any comments on the rumors we read about license plate tracking, video cams, street lights, facial recognition, and all that kind of stuff?
Yeah, well, that's a lot of stuff. So increasingly, there are technologies of physical surveillance. I've called them architectures of surveillance taking hold in the US. And part of it is driven by public safety. That was the theory, at least, of the deployment of the CCTV camera network in Washington and elsewhere. Part of it is driven by certain law enforcement functions, like trying to locate stolen vehicles. And part of it is just driven by what technology enables, which actually takes me to one of my other insights over the years about the spread of the surveillance state, and that is that I think data chases applications. I think if you have the ability to capture license plate numbers, you may not even be sure exactly what you're going to do with that information, but the fact that the data is out there is going to create an opportunity to try to find out. Now, sometimes in the privacy world, we talk about regulating data collection practices. And we say, for example, if you are going to use license plates, you use them only, let's say, to identify stolen vehicles and not to identify people who are gathered at a political rally, which you could probably do, by the way, more easily, right? And in some areas, law can help make those distinctions. But I think in other areas we may need to draw some bright lines. I mean, we have, for example, said there should simply be no subdermal chipping of humans, right? It's okay for pets, it's okay for products, don't do it with people. And you can play out scenarios in which it might be useful to have some type of tracking technique on an undercover DEA agent at the border, for example. But I don't think that's going to turn out well. So in the kinds of examples that you're talking about, sometimes we might be able to deal with them with law. Other times we might need to say simply, no, just don't do it.
I understood public radio article report was that the CIA is considering changing their disclosure practices in terms of what they'll archive, what they'll retain. And I appreciate what it was that you said, that the transparency of businesses and, in this case, government organizations is very important to privacy. The proposal is that the top 22 most important people will have their emails archived. The remainder of the staff will have their emails deleted after 3 years. And that's a proposal, I believe, that the National Archives is putting forward, and there's an opportunity to comment on that until the end of the week. So I was curious about what your thoughts are on that.
Yeah, it's a good question, you know, and I think we are joining with the comments of other open government groups. I would need to check on this. EPIC is in an interesting position in our FOIA request to government agencies, and it bears on this question of CIA policy. We will rarely litigate against claims made by government agencies in support of the privacy of government employees. There are a variety of theories that a government agency can assert to withhold records that we're requesting. They can say it's a national security matter, it's a law enforcement matter, it's an internal communication or confidential advice, or concerns the name or identity of the employee. And as a general matter, you know, given that we're a privacy organization, we will fight pretty hard on most open government claims, where we usually leave identifying information alone in government records. Now, there are certainly scenarios in which it would be helpful to know. If you're trying to examine the revolving door phenomena in Washington, you might want to know, you know, about the movement of people between agencies and private contractors, and there's quite a bit of it. So you've asked a good question. I don't know in the end what our position will be, but I suspect we're going to try to find a way to both ensure you know, the effectiveness of FOIA with respect to the CIA, but probably with some recognition of the identities of agency employees with the agency as we would with any federal agency. So,
Thanks for your time and thanks for your work.
sure.
So I had a question about the Senate bill that's on the floor now, that was it Freedom?
Oh boy, yeah, what a week.
Yeah. So, what your opinions on that was, and also, do you think that it would even really matter? Because I get this impression that the NSA has kind of become this rogue agency that they're spying on Congress members,
Yeah.
and they lie to their face, and things like that. So,
Well,
does it matter to Congress?
I mean, the punchline here is that the effort to pass the Freedom Act in the lame duck session failed on a vote of 58 to 42 when 60 votes were needed for cloture, which would have ended the debate and then led to the discussion of the bill. I have to say, one of the wonderful opportunities I had as a young lawyer in Washington was to work for Patrick Leahy on the Senate Judiciary Committee. I did that the year I came out of law school, and Leahy was then and is still today, I think, a courageous champion of civil liberties, but also someone who's remarkably resilient. He's been pushing that bill through the whole Congress, and he watched on the Senate floor this week as he fell 2 votes short for cloture, and basically said it's too bad it didn't happen, and we're going to just keep going. And it's always been very inspiring to me that he's had that determination. I think he will keep going. The certain key provisions of the Patriot Act expire next May, which almost certainly will force Congress to come back to these issues and try to decide what to do. I do think legislative reform is helpful. The Freedom Act isn't perfect. We had argued for more stuff, but the essential goal of the Freedom Act is the exact same as the petition we filed to the U.S. Supreme Court, which was to end the bulk collection of telephone records of Americans. I mean, that is just clearly too far, too much surveillance activity, and that's what Senator Leahy, that's him, by the way. That's Laura Murphy's the director of the Washington office of the ACLU, and we were in January at a speech given by President Obama announcing certain surveillance reforms. And I would say, also in fairness to the president, he's taken some significant measures to pull in a bit the NSA's activities. He's pushed for greater transparency. We now get to see many of the opinions of the Foreign Intelligence Surveillance Court. We now have some numbers we didn't have before. And as I like to say, we're not in the compliment business, but I actually think they do get some recognition for what they've done, whereas the critics in Congress, who are always bashing the White House for its imperialism or whatever it is, actually blocked the passage of the Freedom Act this week, which was disappointing. So, yes, please.
Is your organization at all concerned about the overuse of background checks, which include arrest records and country-basis implications of that?
Yeah, that's a great question. Yes, we are concerned about background checks. We're concerned about the fact that the Department of Homeland Security today pretty much clears everybody in a private employment contract relationship, which is sort of a remarkable transformation of the American employment market. I was on NPR this week. I don't know if you might have heard this. We were debating the right to be forgotten, which I actually think is a great idea, and it was fully embraced by the High Court in Europe earlier this year, and some people in the U.S. are opposing it and saying, oh, it's that crazy European approach to privacy and all that. And I got them very upset. I said, well, actually, it's very American. That's the Brandeis tort. And secondly, it's in every state law that has a right of expungement, which is how we've dealt with that, in the past in this country. So I think we do have too many background checks. Accuracy and transparency is a big issue, too, because in a lot of situations, there are adverse determinations made about people, but they don't actually know what the basis of the decision is. And by the way, it might not have been correct. So you have these agencies out there that are impacting people's opportunities, their livelihood, their employment, but they become remarkably, they believe in privacy when you start asking questions. So that needs to change. I guess we've got 2 more here. Okay.
I'll offer two and choose which one you think is best, but I don't know if you're familiar with Paul Eichen's research on microexpressions, that they're a window to the human mind, and there's been a combination of tracking microexpressions and facial recognition, so continuous monitoring of anything that the face is giving away that the mind is thinking. You guys have any work on that? And then the other is biometrics. Next 3 months is going to be a step order increase in data because of Apple Watch, Microsoft's fitness band, and that tracks continuous sleep monitoring and heart rate monitoring.
Right.
What do you think about the security concerns around that?
Well, just working backwards, I think one of the best ways to establish accountability for data collection is to require transparency of the company that's collecting and using the data. I actually think if that obligation were really enforced, companies would be a bit more cautious about how much information they collect on people because it would be hard to justify. So transparency is very helpful. Coming back to your first question, I mean, we've spent a lot of time over the last 10 years bringing Freedom of Information Act lawsuits against the Department of Homeland Security, which I've called, by the way, Big Brother's Laboratory, because they are constantly coming up. They have this pre-crime detection system. Oh my goodness, I'm forgetting. I mean, it's really Minority Report stuff. And I forget what it was called, but we got some documents out. And one of the things that you begin to learn about these systems is that they're remarkably unreliable, right? I became very interested actually in the history of the polygraph machine. Forget the author. People who study the history of science are familiar with this book. But there's a very good book on the history of the polygraph in the United States. And it turns out to be a device that's never really been very reliable. But it was used in all sorts of ways to extract confessions from people who didn't understand the technology. Courts have always been very skeptical about polygraphs. But nonetheless, there's almost this fascination, about being able to divine the truth, kind of like putting your hand on the copy machine and seeing what color comes out, at the end. That's either a true or false statement you're making. Apparently that actually works. So who knew, right? Who knew?
Well, I'm concerned about privacy rights and the medical field, especially HIPAA laws, and not being able to gain my own electronic medical records.
Right.
Which may be much more extensive than what summaries they may be able to offer you. Electronic notes from one place to another, I've been blocked in receiving those. In fact, I went through one program sponsored by the University of Washington at Harborview Medical Center, where one of the disclosures was that their records could not be opened by any court in the land. I'm concerned about such, privacy being totally, if you can't open their records, and you were just talking about openness and examination of records and how they handle data. If that's part of what the University of Washington addictions program at Harborview Medical Center is about, and that is what the paper said. I've read them much after the fact when you sign a notice allowing treatment, and you don't read it very carefully, you come down through, and it says that it may affect your health, it may even include your death in this type of treatment. You wonder why they want to try to hide those type of records.
Right.
And saying no court in the land would be able to open those records. Now, I have a feeling that's going on with medical research throughout the United States.
So,
it has been for a long time.
Yeah, I mean, this is a very important question. Actually, we're doing a fair amount of work in the medical privacy field, and one of the points we keep making, it's probably more true here than almost any other area. This really is information about you. I mean, this really is the kind of information that you have the right to access. I think most every state now has a right of access to medical records, which should be enabled by electronic record keeping, but I think many people have had the frustrating experiences actually become more difficult as a consequence of electronic record keeping, and I hope that changes. Before I wrap up, I just want to leave you with one last thought. Since I am speaking here at a university and we're always looking for emerging privacy issues, I just wanted to share with you one issue that we've focused increasingly on that we're very much concerned about is the future of student privacy. And I mean in particular young kids. and the amount of testing and tracking across a whole range of metrics. I'm not just talking about, the midterm on history. I'm talking about how much they participated in class, whether they were smiling or frowning. I mean, it is a whole new world out there in terms of the amount of data that's being collected about kids, and the risk that that information is used in the future in some adverse or stigmatizing way is very real. So particularly, to the educators here, and as you're thinking about the collection and use of data on your students, please keep in mind that, what you have in a particular context for a particular purpose maybe should be kept there. Maybe should not be, so widely shared or carried on into someone's future. So anyway, thank you so much for coming here tonight.